Our guest in the studio this morning is the President of the Law Society of Kenya, Nelson Havi. Once again, welcome, Mr. President.
Thank you, Eric.
So, we said you needed to tell us, now that we can see your outfit. It looks very beautiful, jungle green, with some insignia or emblem. What's this all about?
Well, several advocates in the history of mankind have brought change in the world. There are about three that are outstanding. One is Vladimir Ilyich, famously known as Lenin. The other one is Fidel Castro. The other one is Nelson Mandela. I always believe if there were many Fidel Castros, the world will be a better place. I always ascribe to his ideals.
Really?
This is what Fidel Castro donned for about 45 years that he was in office as the president of Cuba. It's an indicator of change that is development best. It is an assertion as opposed to a revolution, because the right to good governance, democratic rule, is a right that belongs to people as a matter of course. It inheres in them. And often in nascent democracies, you don't find this. Kenya happens to be one of the biggest victims of that. Over the last few years, I've tried my level best to assert that right of the Kenyan people in my individual capacity or as president of the Law Society of Kenya. That is why I don this attire.
Nice. Well, this the 60s, 70s, or early 80s, people would have looked at you and said, this is a communist.
There is nothing wrong in being a communist, because even the capitalists have proved that it's not a system that is transparent and conducive to development.
Right. So let's begin the hour with the day's proverb from C.T. Muga, and then we delve into the conversation.
If you close your eyes, then you will learn through accidents.
If you close your eyes, then you will learn through accident. Applicable in very many ways, right? It's applicable in very many ways in life and very many situations and instances. So Nelson, 5 judges of the Constitutional Court delivered their judgment last week, and it is still reverberating across the globe. First, the LSK was party to this consolidated petition to the court. What was the LSK's specific request?
Well, let me make some clarification. The Law Society of Kenya was not a party to the petition.
Okay.
I happen to have been instructed by 4 spirited civil rights activists, if you may call them, an acronym that has come to describe anybody who seeks to do just, led by Dr. David D. But that notwithstanding, the Law Society of Kenya, as you are very well aware, submitted a very elaborate memorandum to Parliament on the same issue. I appeared in Parliament together with several of my colleagues from the Council of the Law Society to espouse the claim that the BBI bill was not based upon sound principles of constitutionalism, and it was not intended to better the governance in Kenya. But back to the consolidated petitions, the same arguments that were put before Parliament are the same arguments that were placed before the 5 judges. And ideally, if I may just compartmentalize them into 3. One was the case that the Constitution is as a result of many years of struggle by the Kenyan people to arrive at a certain aspiration in the manner in which they want to be governed. A presidential system with checks and balances, where cabinet secretaries are not appointed from Parliament, where cabinet secretaries are vetted by the National Assembly, where the president does not sit as a member of Parliament, where the judiciary is independent and accountable and not beholden to the state. The other aspect of it that was mounted onto the primary argument was this, that there are two aspects towards a constitutional change. A constitutional change can either be effected by a parliamentary initiative. This is an origination by the parliament itself. And remember, in a presidential system, often the president has control of the entire house of the National Assembly and the Senate, so that if he seeks to originate any legislation, if he seeks to alter the constitution so far as it's permissible, then it has to be done through the Attorney General or through a private member's bill in the National Assembly. And then on the other hand, the constitution reserved a portion for the common mwananchi, popularly known as Wanjiku, so that if Wanjiku, Ndu, Muga, or Latif, in conjunction with Havi, are of the view that they need to renegotiate the manner in which power is exercised by those they elected into office, then they can bring about constitutional change. Then lastly was the procedural aspect of it that started from the beginning. How the idea was conceived. Was it a people-driven idea? How the signatures were verified? How the bill was processed through the county assemblies? Was there public participation? Was there an enabling framework to pursue this enterprise? And then to cap it all, it was the argument of the petitioners that what we have in actual fact is not a constitutional amendment initiative, but it is an entire overhaul of the Constitution. Because you need to demarcate the boundaries between an overhaul and an amendment. By the time we had the 1969 Constitution, we had incorporated about 18 amendments. By the time in 1996, a constitutional change program was put in place, we had about 34 amendments. The BBI bill came with more than 90 amendment proposals to be effected all at a go. Now, from a panoramic view, that is what the judges had to deal with and arrive at that outcome, invalidating the entire process.
There are many people who have made several comments. One, let's look at, for example, a senior counsel, somebody who's experienced in law and even the journey towards the current constitution, Kiraito Morongi, the governor of Meru, who is also the chair of the legal committee of the Council of Governors. He says, whereas I look at the judgment that has been delivered, I also ought to caution that judges need to look at the other side, because we are living in a political situation. They also need to consider the political side of things. And as they are making their judgment, they should also be, cognizant of what else is happening around the country. Have we been having issues with political disputes after every election? Is this document, is this particular process seeking to resolve that? And when you put a halt to everything else, are you then putting a halt to that journey towards making sure that we no longer fight after every election? There are those that say such kind of things, that the judges did not necessarily balance their judgment and the interpretation of the law and the Constitution with the reality on the ground.
Well, there is a false construct that has permeated the minds of modern-day Kenyan politicians. They tend to proceed from the premise that laws are suggestions, they are suppositions. They fail to understand that a constitution is a legal framework upon which the affairs of man are determined, albeit in the political environment. And it is something that is of great concern because, and I've said this in a different setting, that the problem we have in Kenya is not the chair, but it's of the chairmen and the chairwomen. Whenever they sit on a chair of leadership, they fail to understand that they are there for a temporary period to serve in trust for the people of Kenya. And it explains why they will always come with lamentations of the kind that you've just enumerated, where they say that the judges ought to have considered the political environment. And as we discuss this, there is another aspect of that argument which they will term as public interest. What is the public interest? As Eric has pointed out, we need to have a peaceful election, a transition that is conducive to ensure sustainability of rule of law and democracy. But what really is the problem? If you look at it from the background that I set, you realize that the crop of leaders we have right now have very little regard for the Constitution itself. Yet when they are sent to office, the first document upon which they take an oath is the Constitution itself. You can't claim to be a preacher, be it a Muslim or a Christian cleric, and then everything you say is outside of the Quran or the Bible. You end up creating your own dogma. So it is my honest view that there is nothing wrong with the Constitution of Kenya. The malaise that we suffer in our current leadership is one of want of proper implementation and not one of demand for reform and constitutional change. And this is a view popularly shared by many Kenyans because, well, when BBI was being sung and danced all over reggae platforms, so it invited so many people, the audience and the participants. I can't blame them because many of us listen to Lingala. We always dance to Lingala, but we hardly understand what Franco Lombolonzo Makede is talking about when he's campaigning for Mobutu Sese Seko. It's a common dancehall song. So there is need for us to be a little bit more vigilant, irrespective of our stratification in the society, and understand that there is an arrangement between the people and the leaders, commonly known as the social contract in law. And the leader in office must always conduct himself or herself in accordance with that social contract.
Okay, so Havi, if we're looking then at this judgment specifically and what happened and what the judges then ruled on, according to the law, not to be bent or broken, should they have taken into consideration the political atmosphere or should they just have followed the law, in your opinion?
Judges make decisions based upon three things. One are facts. Two, the law, and third, what is just. Now, the issues that were framed before the five judges were all anchored upon the Constitution. I can say there were no contested facts. For instance, when we say that this was not a popular initiative, it was a presidential initiative, are there two interpretations to that fact? None. Now, what does the Constitution provide? You can amend it either through the parliamentary initiative or the popular initiative. And a dichotomy was created between the people and the governors. The moment you assume state office, you cease being the people. So that in the preamble to the Constitution, we the people of Kenya encompasses you. You understand? And the moment you've placed your leader at that elevated level of President of the Republic of Kenya, he ceases being the people.
Part of the we the people.
You understand? No wonder in medieval times, or even as democracy progressed, the people could say, we are dissatisfied with the king. If it is King Louis, if it is King Albert, if it is King Gustav, we are disappointed with the king. He got to go. We got to create another kingdom, or we have to replace it with a republic. So look at it from that perspective. You realize that the political connotations that are being now placed on the judgment have no foundation whatsoever. It's a judgment that is sound in law. It's a judgment that is there to protect the people of Kenya. It's a judgment that is there to sustain good governance and democratic rule. And I say this with a lot of authority because in the last 8 years that President Uhuru Kenyatta has been in office, you will be surprised to note that almost 80% of the decisions that he has made, administrative or otherwise, if challenged in court, succeed. It is a big problem.
When you talk about the law, the implementation of it, and then you bring in a component called a layperson like myself and ourselves and our understanding of it, I want to begin here. 3 arms of government.
Yes.
The roles are stipulated and they are understood. But what are the boundaries? At what point, for instance, does Parliament's role in this process that we are discussing become central to it or fundamental? At what role does the President, the executive, and at what the role of the judiciary, we understand. Mm-hmm. What are the limits to these roles? And at what point can they crisscross? At what point does one sort of like wade into the purview of yet another arm of government? And what I'm asking is, are they really honestly separate?
Good question, Muga. The 3 arms of government, they are intended to be independent but interdependent. They exercise well set out functions. But let's just look at the function that is core to this judgment. That is legislation and constitutional amendment. Now, Parliament is given the primary function of originating law-making processes. And then it deliberates what is supposed to be formulated into law. People participate in 2 ways. One, through the elected representatives, and another one is through what we call public participation, which has been brought about by the Constitution. So that if you elected me into the National Assembly, you still have the right to come to the National Assembly and present a memorandum. And then when the laws have reached the penultimate stage of deliberation in Parliament, then they have to be made into a document that is capable of enforcement. In law, we call it enactment. So that Parliament will have passed the bill, but it requires the sanction of the President by way of assent to constitute it into law. And then the executive, through which the President acts, implements those laws. On the other hand, the judiciary arbitrates on any dispute arising between the state and the people, or between the people and or amongst the people. Now, what are the boundaries? The boundaries are as good as this. You see, I may walk with my arms like this, but I should ensure that they don't hit your ear. Often, the strongest of the 3 arms of government is the executive, because the executive has the purse and it has the gun. It facilitates and then it coerces. You understand? Now, the legislature may come next. The judiciary is traditionally seen as the 3rd arm of government. And it's for that reason that people who do not respect the rule of law will tend to relegate the judiciary as being the lowest arm of government. But fundamentally, the judiciary, in my view, plays a pivotal role in ensuring that the other 2 arms of government act within the parameters they are given by the Constitution and the law. And even the judiciary itself is still accountable in the manner set out in the Constitution. But one thing that we must understand, even in the most developed democracies, leaders at the echelon of power will always find the law as an inconvenience. Richard Nixon, a Republican and a very prominent lawyer who rose to the leadership of the United States of America, once quipped, "I thought the president was above the law." So if you look at it from that perspective, Muga, it's not just a conundrum that prevails in the mind of the layman. You rightfully posed the dissatisfaction by Governor Kiraitu Murungi, a distinguished lawyer, Harvard Law graduate, who stood firm in the quest for the second liberation. Let's go to a country like Malawi, a professor of law like Mutharika, who still finds the constitution and the law as an inconvenience. You understand? But these are the checks and balances. If they are sustained, then democracy will prevail. So there's the possibility of all the three arms, or one of them, overreaching. But with the accountability mechanism put in place, you're able to see. So that if somebody was to state right now that the judiciary was overreached, then we'll tell them, let's look at the yardstick. To what extent did they overreach?
Yeah. Let's take a break at this point. 26 minutes after 8, having a conversation with the Law Society of Kenya President Nelson Havi, who's in the studio with us, understanding and unpacking the judgment by the 5 judges of the Constitutional Court last week. We have heard from the proponents of the BBI that they will be appealing that particular judgment. So that's what we're looking at shortly. As we get moving with the conversation, Nelson, looking at what the proponents of the constitutional change have said that they want to argue when they go back to court is, first of all, a number of them, the issues that they're raising is on the interpretation of popular initiative, on whether popular initiative is by initiating or by decision making. Who can initiate a popular initiative, because the court said that the president cannot initiate the popular initiative, and also the BBI steering committee, whether it was part of the initiators of the popular initiative. And they've argued that none of these things holds. Then there's the other side of the conversation, which is still related. The people spearheading the secretariat of the BBI, this is Junaid Mohammed and Dennis Owero, when they were addressing the press on Friday, they said, actually, we are the initiators of the popular initiative. But then the people who are going to court to file the appeal include the Attorney General of the Republic, the Solicitor General, and others. So does this bring in that argument of, is this a Junaid popular initiative, or is it a state popular initiative?
Okay. Let me take this sequentially. Popular initiative and parliamentary initiative. In the most simplistic way, if you were to go to a village in Nyalgunga or in Karachonyo, you will say there is Serikal and Wananchi. The popular initiative is by Wananchi. The parliamentary initiative is by Serikal. Now tell me, is Uhuru Kenyatta Serikal or Mwananchi? If you answer that question, you realize that an appeal as against that particular finding has a snowball chance in hell. It is as simplistic as that. If you see a Land Rover coming to your village with a GK plate, during our days it was either green or white in color. Serikal had come. If you saw a Peugeot or a Vewe, a KRW, then you know it was a teacher. It is Mwananchi. So that dismembers that entire argument. Let's go to the steering committee. The proponents of this thing, led by Paul Mwangi, have really gone to town lambasting the judges that Justice Mwita Justice Mativo had ruled that the president can set up a task force to advise him on how to go. But what the court ruled upon on the 13th of May was the legality, the constitutionality of the BBI steering committee. And you see, it is the BBI steering committee that birthed this BBI bill, together with a raft of other bills to be enacted into law to supplement and effectuate the initiative itself. And the court said the steering committee is an unconstitutional entity, is an animal that is not known in the constitutional animal kingdom. And we must contextualize this. We are in a constitutional setting where if you as president has to constitute a body, then you must revert to the constitution. You must revert to any laws enacted subsequent to the Constitution. There is no law that the president cited as enabling him to create the steering committee. Again, the courts cannot be faulted. Dennis Waweru and Junaid Mohammed have said they are the popular initiative. You see, this is the folly of firing your lawyer and acting for yourself. These two individuals decided that what Senior Counsel James Orengo has opined, what Senior Counsel Otiende Mola said, is just English and common sense. We'll be able to navigate through the sea by ourselves. Of course, these fellows have sailed many journeys in turbulent waters, but they're not the coxswain. There is no way they will extricate themselves from the fact that this is a presidential initiative. And it doesn't matter how much noise they make. It is a lame lamentation.
I want you to take a mental journey with me. We have issues that clearly are heading towards the Court of Appeal and probably will end up in, well, no, let me rephrase. Will certainly end up in the Supreme Court if the Court of Appeal judgment does not please those who have taken the matters to the court. Now, fast forward it to the point where we will be electing our leaders in 2022. So, what scenario do we have? Is it the same platform that we've had before that people have been lamenting about that brings about the turmoil that we see every 5 years? And the consequences of that situation that we have and the issues that are raised, because the point that I raised, I have read through, but apart from what Kiraitu Murungi pointed out, every other discussion around this BBI have been legal. I'm talking of the social, political, cultural consequences of going into an election with the same scenario that we've had from time immemorial that brings about the issues that are argued to be the very fundamentals that brought about the issue of the BBI. In your mind, from a legal perspective, what do you see as the position that the country will be in if that is a situation we head towards?
Well, you give it a manual to operate a machine. These individuals have been given a manual to run government. It's called the Constitution. Now, how do you put in place individuals who will serve for 5 years? It's through an electoral process oversighted by the IEBC. Now, they have weakened the IEBC. They have made it incredible so that it cannot guarantee a free and fair election.
How have they weakened it, Mr. Havi?
IEBC has been operating with 3 commissioners for the last 3 years. Yes. The court ruled on the 13th of May that much as the Constitution gives you a maximum of 9 and a minimum of 3, yes, there are enabling statutes within which individual commissions operate. Parliament enacted a law that says the quorum for the IEBC shall be 5. But look at it from a very objective point of view, Juduong. 3 commissioners. 3 to oversight a very serious enterprise of this kind. What if one of them falls sick? God forbid, what if one of them dies? You see how perilous that setting is. And this has been sustained by the refusal of or failure by the president to declare vacancies when necessary. But
what would be the silent reason as to why that wouldn't be done? Because it is clear that it is a necessity. Yes. Why not have it done then? What would be your reasoning behind the president not declaring those positions vacant and saying we actually need this to have things running?
It's to weaken and make it vulnerable. You see,
to what end?
I mean, tie one of your hands behind, or let it be tied by somebody. Let's engage into battle. Mm-hmm. I'm incapacitated. I don't have full potential. You understand? I'm most prone to an armistice. I'm likely to do that which you may propose either by coercion or by seduction. And that is what is the problem. And then, Muga, you raised a question.
Yes.
Will we be in the same scenario in 2022? Look at what BBI intended to bring about. It intended to give us a prime minister, 2 deputy prime ministers, and a cabinet domiciled in the National Assembly. Haven't we heard that before?
Yes, we have.
In fact, it was the compromise in February 2008.
Yes.
Was it sustainable? How much does it wear down on the wage bill of the common mwananchi? You're creating job opportunities to be shared at the peak of leadership. That is not what the people of Kenya intended when they put in place this constitution. And you may want to look at one self-detonating clause of the constitution, for instance, the one on dissolution. If you don't do it, then you cease to exist until such a time as you do it. You understand? Let me speak to my villager in Lekuyane. This tell that the monkey was invited to a feast. So it was told, fine, go and wash your hands. It went and washed the hands by the river, then used the hands to walk
back.
Yeah, then go back and wash. You understand? So until the monkey learns to walk on the real limb, it will not participate in the feast. So these monkeys that are at the helm of our leadership must realize that the feast has certain rules upon which they must subscribe.
Okay.
And they should not threaten the people of Kenya, because unlike any other constitution in the world, power at the 3 levels of government is
Mr.
people
Havi,
anchored.
you're assuming that the people of Kenya feel threatened.
The people of Kenya, I think I may agree with you, do not feel threatened. Often they are impervious to pain and they want to persevere for a while. But they will reach their breaking point.
There will be.
They'll reach
The
their breaking
politician is a
point.
very litmus-sensitive individual.
Yes.
And they take the cue from the people usually. It may appear like they don't, but they actually do. If they perceive, even in the slightest, that what they are doing may not necessarily be acceptable. The song and dance that you mentioned with reference to the BBI, what was all that about? To get people to sort of like a quiz, to sort of like say, okay.
Yeah.
If they didn't consider the general public, if they didn't consider them relevant at all, they would not bother with all that song and dance.
No, they consider the people gullible. Perhaps they have misinterpreted what Emperor Napoleon Bonaparte said. He said this. The people can make you emperor. The people can also make you prisoner. And you see, whilst they have made you emperor, you want them to continue sustaining you in office. You fail to realize that they can make you prisoner.
In making you emperor, they've actually made you prisoner.
Absolutely.
This is really it. It's 2 sides of the same coin. It's not 2 separate coins.
Exactly.
Let me tell you where I'm going with my train of thought.
Yes.
In this discussion, we are not talking about another arm of government. That's the parliament. From what I have read, there was a little issue of a framework within which we can actually hold a referendum. And that, I believe, that particular task is a specific purview for Parliament.
Yes.
Not the executive, not the judiciary. All right? So even as we're discussing these things, if that doesn't exist and a referendum is necessary for us to get to the point where we wanted to go, where on earth were we going to go with all this in the absence of that particular framework?
Yeah, you see, it's a permeated environment where we are being pushed as the people, the mwananchi, by Serikal to go to a referendum. Yet there is no framework. What is the outcome? It will be a manipulated outcome. And I do not think this is negligent or recklessness. It is premeditated.
Okay, so Nelson, I have to ask you then, because those are the questions that are rising right now. That the judgment in the way that it came out, over 20 factors or elements that came through, that it would seem as though you walked in blind. You walked into a process not knowing that there was no framework, no legal framework upon which now you are acting. Is it possible that you had so many people, and an attorney general who was asked several times and who made public statements about this BBI being sound, being solid, about this bill being solid, several people across a legal fraternity, a committee that was made up of some of the brightest brains in this country legally. Why would it be then that there are so many mistakes then that have been pointed out by this ruling? How is it possible that they walked in with so many holes in this thing, according to this ruling, and they did not know or did not choose to pay attention to it? Why?
No, they knew everything that they were doing, but the framework upon which they operated is quite fundamental in understanding their mindset. As I've said, where are we right now? We have a parliament that has been declared unconstitutional. We have an executive that has been declared unconstitutional. And I will just pick two fundamental aspects. Failure to comply with the two-third gender principle. You get it? And they have said, we will continue governing, that notwithstanding. So to them, the constitution has become an inconvenience. And in the midst of that, they managed to convince a few gullible Kenyans. You understand? They managed to coerce a few leaders. They give MCAs car grants. They threaten members of the National Assembly and the Senate to subjection. You understand? You end up with this product, forgetting that Kenya is a country ruled by the rule of law, and there are those that are vigilant. And if you remember, when I appeared before the Committee of Parliament on the 11th of March, I was ridiculed. I was made to look like a fool in the market, not by the lay legislators, but by lawyers. You understand? So that you look behind and ask yourself, is something wrong with myself? And that is the feeling that most Kenyans tend to have. You want to feel as if you belong. Let me also start dancing reggae because it's the only tune in this club.
Yep.
Yet you don't ascribe to it. You understand? Now, it was apt that the court had to put instant brakes on this perilous safari because the driver was blind. The conductor was blind. The passengers were blind. They were just singing reggae as the bus was driving towards a cliff. And this is important. That is why we need to have a judiciary that is independent and vigilant, no matter the coercion. You understand? No matter the threats. Otherwise, the fabric that ties together Kenya as a constitutional democracy will not be sustained. And it's fundamental because people will tell us, why don't you go to the streets? We don't want to go to the streets. We have a constitution that enables us assert our will. If we were in the 70s, I would have thrown my phone and my law books, strutted a Kalashnikov and gone to the bushes. But we are beyond that medieval stage in the Kenyan constitutional framework.
So you've been talking about Sirkal and Wananchi for a long time.
Yes.
Okay. Now let's come to the reality. Should this Sirkal decide, you know what, we're going to a referendum? And we've even heard the political players and senior government officials talking and intimating this. Yes, we have seen what the judges are saying. We have issues with what the judges are saying. We are looking at all the other options available to us, including now taking this thing through Parliament and having a parliamentary initiative, if that's what you people want. But we are going to a referendum. Then what, Nelson? If the government decides, you know what, we are going to have a referendum, come what may, including some of those things we can, amend one or two things here and there. But the overall picture here is that we must have a referendum.
There is a Swahili saying that mbio za sakafuni huishia ukingoni. Muga, when you get time, translate it to Ndu.
Yes,
it's a journey to nowhere. They're determined to reach nowhere. And if they are so determined to reach nowhere, I think their arrival may be sooner than expected. Look at what happened in the National Assembly and the Senate. A majority of the parliamentarians voted yes. Does it not alarm you that with such a repository of legislative experience, some derived from the best lawyers that we elected into Parliament, we end up with such an apocalyptic outcome? And the judges point out I've read the papers from the 14th. It's a damning indictment against the legal minds behind the thought pattern of President Uhuru Kenyatta and Prime Minister Raila Odinga. I mean, it's a mistake that ought not to be made.
Okay.
But more fundamentally, and somebody has posed this question, where has the international community been? You understand? Sometime last year, I had an opportunity of speaking to the envoys from the Western world, and I pointed out to them the flaw in this enterprise. Surprisingly, it appears to have been sustained, supported financially, and even logistically by the international community. There is a problem in Kenya. Do they want us to go to the level of DRC? Do they want us to degenerate to a level that is beyond redemption?
Mr. Havi, the question you ask, I assume, is rhetorical, but the truth of the matter is this. Our neighbor down the road here is called Uganda.
Yes.
That president has been blamed and has been stated that he has manipulated his stay in office for the longest possible time. He was sworn in the other day as president. What you are referring to as, or alluding to as, might be apocalyptic is the assumption that the BBI and everything that it purported to present is something that is abhorrent to the citizens of Kenya. Is it really? Do you think that the citizenry of Kenya share this view with the judiciary that this thing is the worst thing that could have ever happened to us and that is something we must get rid of? I think not really.
Okay. You see, the 5-minute conversation with the average Kenyan, as Winston Churchill will have placed it as an exemplifier of what democracy is, will enlighten everybody who has doubts about it. Did I not see a celebration in Baringo the other day being dispersed by the police because they were happy BBI had come to naught? Did I not see a similar celebration in Kerugoya? But contextualize it. We are in an environment where the executive continuously makes public orders to confine you so that you're not able to speak, you're not able to move, you're not able to voice your concern. You get it? They open the country temporarily just to go and dance reggae. The moment they reach the crescendo, then they close the country. It is the environment in which they have sought to propel this initiative, which may tend to conceal the inner feelings of the common Mwananchi. But even my manager at home, Franco Luambo Makambo, will tell you, boss, hii BBI inatupeleka wapi? Mimi sioni kama inatupeleka mahali pazuri. The other day I was in Kisumu and they told me, Okil, wewe ni Okil ya baba. Unahakika kwamba baba ako na nia yetu kwa hii BBI? Then I told them, mimi kama Okil ya baba nimemwambia hii kitu haina msingi. And then look at it. Where are babas Okils in this enterprise? Where is James Orengo? Where's Julius Weto?
They voted yes.
Where's Otende? No. Forget about those ones in parliament. Look at the ones. Look, Eric Latif. If Baba is pursuing a genuine cause in court, you will see James Orego, Otenda Molo, Nelson Havi. You understand? Julius Weto, et al. You understand? Flagging him. If he's not, then whoever is flagging this must be flagging a dead horse.
Time for us to take a break. Say goodbye to our audience on KTN Home. You've been with us since the top of the hour, coming up to 4 minutes to 9 o'clock. The conversation is with the President of the Law Society of Kenya, Nelson Havi, just trying to understand the BBI judgment and what comes out of it, and then the next steps. That's where we are right now.